So we're going to be talk about quickly are Canada's obligations to prevent and punish war crimes, crimes against humanity, genocide and torture. They're all considered crimes that threaten our very survival. Over the past 65 years, the international community has developed a system of laws to prevent war and to criminalize certain human rights violations considered so grave as to be a threat to global peace and security. These laws that have been developed outlaw torture, genocide, prohibit war, and criminalize war crimes and crimes against humanity. The purpose of this international system of laws is to stop war and prevent the consequent atrocities that have claimed the lives of millions of people in this and the past century. Now I'll just briefly tell you what is meant by the terms crimes against humanity. And crimes against humanity refers to acts committed as part of a widespread or systematic attack directed against any civilian population, and includes murder, unlawful confinement, enforced disappearance, extermination, forcible transfer, torture, rape, persecution against a group, and causing suffering or serious injury. The term war crimes refers to acts committed as part of a plan or policy or as part of a large-scale commission of such crimes, and they include all grave breaches of the Geneva Conventions, willful killing, torture, inhumane, extensive destruction or appropriation of property not required by military necessity, depriving a prisoner of fair trial rights, unlawful confinement or deportation, using weapons that kill indiscriminately, directing attacks against civilians, attacking undefended towns, villages, or buildings, launching attacks that will cause death or injury to civilians or long-term damage to the environment that is excessive in relation to the military advantage anticipated, killing a combatant who has laid down his arms. I read through those partly for your information and partly because I know that in listening to them you'll recognize pretty well all of those things as crimes that have been committed by the Bush administration. Some of those offenses are war crimes, crimes against humanity, criminal offenses and grave breaches of the Geneva Conventions. Torture is one of those crimes that fulfills all of those categories. Now, the passage of this system of law, one of the reasons why our politicians and our public servants are so loath to acknowledge the existence of the law or to enforce them is the development of those laws has actually radically altered the power balances in the world. Two of the ways in which the laws radically change things is it's radically altered the sovereign right of states to conduct their affairs free from legal interference or consequences imposed by other states. And number two, it's altered the legal duty of states to prevent and punish violations of internationally protected rights occurring outside their own territory and against foreign nationals. In addition, the laws make individuals personally responsible for crimes committed while acting as a state agent or in the course of following orders. In addition, there is no longer any immunity accorded to heads of state or other high-ranking state officials for these crimes. Now, states becoming party to the treaties creating these crimes, and some of those treaties are the Geneva Conventions, the Convention Against Torture, and the Rome Statute, are obligated to enact and enforce effective measures to prevent, prosecute, and punish these crimes wherever they occur, and as part of the global scheme, states are required to eliminate safe haven from prosecution for suspects and therefore end impunity for perpetrators. In order to fulfill this legal duty to effectively prevent and punish crimes, Canada and other ratifying states have adopted some form of universal jurisdiction. universal criminal jurisdiction, which gives domestic courts the jurisdiction to prosecute the crimes that I've mentioned, and I'm just going to use torture throughout the rest of my talk as an example, although torture is different from the other ones, but with respect to universal jurisdiction, it's the same. So that the universal criminal jurisdiction gives Canada and other states, they have to adopt the legislation giving them jurisdiction to prosecute torture wherever it occurs, whatever the nationality of the victims is, and whatever the nationality or the status of the suspected perpetrators is. And the whole concept of universal jurisdiction is based on a consensus within the international community that some crimes are a threat to all humankind, and therefore all states criminalizing those acts have to participate in preventing and punishing them globally. And UN monitoring bodies, of course, have no power whatsoever to monitor or control, prevent, or punish any of these crimes. The International Criminal Court, it's important to understand, obviously Diane Watts doesn't understand anything about the criminal court. If you saw the little news clip from her being interviewed by the Georgia Straight today, the International Criminal Court is a court considered a court of last resort and only has jurisdiction when either the accused is a national of a party that a country that has signed and ratified the Rome Statute, or the crime took place on the territory of a state that has ratified the Rome Statute, or the United Nations Security Council has referred the situation to the prosecutor to be dealt with under the Rome Statute. Now, even when one or more of those conditions exist, of course, the International Criminal Court doesn't take jurisdiction unless there are no national courts that are willing and able to do so. So when anybody says to you, oh, the International Criminal Court could take care of that, you can usually say, no, it couldn't. So in the case of the United States, for instance, because the United States is not a party to the Rome Statute, then the International Criminal Court has no jurisdiction over crimes committed by the United States except when those crimes have been committed in the territory of a country that is a party to the statute. So, for example, the International Criminal Court has jurisdiction over some of the extraordinary renditions that were carried out by the CIA because some of the secret prisons were in European states that belong to the International Criminal Court, such as Poland, and so in that very limited circumstance. But it's a very common mistake that politicians make. They think that the primary method of enforcement is through the International Criminal Court, and that's not at all true. The primary method of enforcement is through domestic criminal law systems and criminal justice systems, and the International Criminal Court has very limited jurisdiction. Therefore, because enforcement is primarily a domestic court situation, you can see how important it is for states like Canada to honor their legal duties. Now, to look at the example of Canada's obligation to enforce one of those crimes, I'm going to use the example of torture and Canada's failure to enforce that crime. In 1985, Canada passed the Geneva Conventions Act as part of its duty in ratifying the Geneva Conventions, under which torture as part of a conflict situation is a crime, and many other things are crimes too. And then in 1987, Canada ratified the Convention Against Torture, And as part of their process for ratifying that convention, they passed Section 269 of the Criminal Code, making torture a crime, and they passed Section 7 of the Criminal Code, giving them universal jurisdiction over the crime of torture. And under that section of the Criminal Code, there's triggering events that trigger the jurisdiction, and one of the triggering events is when a foreign national who's suspected of committing torture crosses the border into Canada. That triggers the jurisdiction to the offense then becomes a Canadian offense. So for example, with George Bush, when he crossed the border into Canada, then all of the torture that he's accused of, including the torture that he's admitted to, are deemed to have been committed, deemed to have occurred right here in Canada. So that obviously triggers the statutory and common law duty of the police, whether they're RCMP or municipal police, to enforce the law with respect to that crime. There's another factor, though, that comes into play because it's an international crime, is that Canada owes a duty not only to all Canadians but to the whole world to ensure that a foreign national suspected of committing torture outside Canada, when they cross the border, Canada has a special duty to ensure that they're prosecuted, whether and they have a choice of prosecuting the person in Canada or extraditing them somewhere else to a country that's willing and able to do so. They don't have the option of simply ignoring it, and in fact, in one of Canada's international law obligations is not to treat as legal international crimes. And so obviously by allowing Mr. Bush in without taking any legal process against him is tantamount to treating the torture that he's accused of and that he's admitted to as legal. Now, in one of the other international duties that Canada has is the duty to prevent safe haven, and all that refers to is the legal duty to ensure the enforcement of the criminal law prohibiting torture, that the law is enforced against all suspects irrespective of their nationalities, thereby ensuring accountability and preventing impunity. It's also intended to restrict the ability of suspects from country shopping, so from going to countries where they know that they will be safe and immune from prosecution. So in furtherance of that duty to prevent suspects from coming into the country and having safe haven, Canada enacted the human rights inadmissibility provisions of the Refugee Protection Act, and those provisions bar entry to Canada of anyone suspected of complicity in torture and other crimes. Now, under Section 35 of the Act, people suspected of having committed outside Canada torture or any other offences referred to in the Crimes Against Humanity and War Crimes Act are barred entry. They're inadmissible. Again, under Section 34 of the Immigration and Refugee Protection Act, persons suspected, I should say, of engaging in or instigating the subversion by force of any government are inadmissible. So there again, Mr. Bush would be inadmissible in law under that section, as he's not suspected of overthrowing a government by force. The Iraqi government and the Afghanistan government are two examples under the Bush administration. He's known to have done that. Also inadmissible under the Immigration and Refugee Protection Act are senior officials of any government that has engaged in, quote, systematic or gross human rights violations, or a war crime, or a crime against humanity. So Therefore, Canada's first duty with regard to Mr. Bush was to bar his entry, and this could have been done diplomatically and privately, as was done by the government of Switzerland in February, when they obviously advised Mr. Bush that they couldn't guarantee that he wouldn't have criminal proceedings brought against him while he was there. He was invited to give a speech in Geneva in February, so he cancelled the engagement, or it could have been publicly done, as was done by the Mayor of London, England, Mr. Johnson, who, when Bush announced the book tour, he said that we don't want you in England, and we advise you not to come to England on your book tour or to any other European country, and that if you do, you might never see Texas again, due to the threat of being arrested in accordance with our legal duties for authorizing the widespread use of torture. Mr. Johnson went on to say admittedly, there are political forces at work in the UK and in other European countries that would try and prevent the enforcement of the law, but said to Mr. Bush, don't count on that. When a suspect such as Bush enters Canada, the legal duty to prevent safe haven persists, but shifts to compelling the authorities to ensure his prosecution, and that's why several organizations, not just Lawyers Against the War, but Amnesty International, Human Rights Watch, the Canadian Centre for International Justice, and the New York-based Centre for Constitutional Rights, all advised the Attorney General of Canada that the legal duty, if Mr. Bush crossed the border, was to arrest and prosecute him, and what they meant by that is the legal duty was to ensure that he was prosecuted here or elsewhere, and the obligation to ensure that a suspect of a serious crime is prosecuted means that the police have to secure that person's presence in the case of a foreign national, because they might just cut and run out of the country, and securing their presence, of course, means arresting them. Now, the inadmissibility provisions of the Immigration and Refugee Protection Act are invoked thousands of times, so any person seeking to enter Canada for any purpose or any length of time everybody coming in has to present themselves for some kind of assessment to a Canadian Border Service Agent official. If a person is coming from a country that requires a visa, then usually presentation of a visa is all the assessment that's necessary, because the assessment's been done prior to the visa being issued. Otherwise, the CBSA official conducts an inquiry at the entry point, and if the CBA has received credible information that the person is suspected of involvement in a human rights violation, the person must be barred entry. Now, that's obviously happened in George Bush's case. Lots of people have advised the CBSA, they've advised the Minister of Immigration, who's in charge of the CBSA, or the Minister of Public Safety, the Minister of Immigration, and the Attorney General. I might say that in spite of the substantial nature of the briefs that were sent to all of these government officials by the human rights organizations that I've mentioned, not one of the organizations has received a reply from any of the ministers addressed. So now, Canada, on various Department of Justice websites, you'll find that Canada announces proudly its the fact that Canada, one of the websites has, one of the quotes is, "Canada is not and will not become a safe haven for persons involved in war crimes, crimes against humanity, or other reprehensible acts, regardless of where or when they occurred." Another report of the War Crimes Program says the most effective way to deny safe haven to people involved or complicit in war crimes is to prevent them from coming into Canada. That's quite obvious. Just some examples of the number of people assessed and barred each year under those provisions. The 2005-2006 report, there was over 3,000 assessments made of people seeking entry into Canada, and of those, 370 were barred in the 10-year period between 97 and 2007. 3,700 people were barred entry or removed on the basis of Section 35 of the Immigration and Refugee Protection Act alone. And another method under the Act is also open to the officials. That's where Canada has designated a regime as being known to have been involved in war crimes, and many of those designations have been made. Now, recently the federal government published a website, or created a website, where they published the names and photographs of several people in Canada that they said they now knew were suspected were complicit in various kinds of war crimes, and they invited Canadians to turn these people in. So you can see that they're pursuing the no safe haven doctrine quite vigorously with respect to some people. And of course, under Canadian law, they're obliged to pursue enforcement of the law equally against all people. The right to equality and the duty to to give equal treatment under the law is a charter-protected right. It's also the basic, most underlying principle of the rule of law, which is enshrined in Canada's Constitution. So in spite of that, when all of these organizations called upon them to honor the safe haven law and principle, they never listened to any of them, even though the most recent letter sent to the Attorney General of Canada by the Centre for Constitutional Rights and the Canadian Centre for International Justice was signed by organizations from a huge number of countries, and I'm just going to read you some of those countries in addition to Canada: the US, Brazil, Germany, Ecuador, Lithuania, Finland, Sweden, Peru, Serbia, Panama, Nicaragua, Guatemala, Turkey, Colombia, Switzerland, Denmark, France, Kyrgyzstan, Chile, Morocco, the Philippines, UK, and Thailand. So human rights organizations from all those countries signed on to the most recent letter from those organizations that was specifically reminding and calling on the Attorney General of Canada to, if George Bush was allowed in the country, to arrest him and prosecute him for torture. So why does it matter then? Why can't the former president of the US, Canada's largest trading partner, come to Canada and give a little talk or fish or just visit? That's certainly a question that I've been asked on a number of occasions by journalists, and the answer that I try to give them is because enforcement of the laws prohibiting torture and prohibiting illegal war and prohibiting the illegal slaughter of civilians and other atrocities, enforcing those laws is absolutely the only method that we have. Preventing those laws by enforcing the law according to the rule of law is the only peaceful method we have of preventing those atrocities. If a country as well thought of as Canada flouts the law and says, well, actually, we won't bother enforcing it. In fact, we will instruct our crews of policemen to arrest the protesters that seek to call upon them to enforce the law, then that really is tantamount to promoting, encouraging the continuation of those laws, of the continuation of torture and the continuation of illegal wars, because it gives notice to other heads of state who might be thinking of using those illegal policies and practices, engaging in those illegal activities, to say, well, look, Canada wouldn't prosecute us. We could find safe haven from prosecution in Canada. Canada would provide us with immunity and impunity. Today, when Diane Watts was interviewed by the reporter from the Georgia Strait, she, as I said, she told him, oh, well, you know, this is an economic conference, and, you know, if the International Criminal Court wanted to prosecute Mr. Bush, well, that would be one thing, but she was only interested in talking to him about the economy. When the Strait reporter asked her what she thought of torture, she walked away. Now, but we need to, our duty as responsible citizens is to make sure that Diane Watts, oh, and she also said, I'm not a lawyer, so that was her excuse why she didn't know what the law was. So it's our responsibility as citizens to ensure that she does know what the law is, and that she's held accountable for inviting him here and rolling out the red carpet for him. Not only Diane Watts, but all of our other elected representatives. And those number just about everybody. Christy Clark was there at the meeting today. So was she there carrying a message for the people of British Columbia, saying that in British Columbia we honor the ban on torture? Was she there decrying any of the crimes that George Bush isn't just suspected of but is known to have committed? No, she wasn't. She was there saying, I think that she was spouting some inanity, I forget what it was, that she was going to be the poster girl for investments in Asia or something of that nature. But anyway, she never said a word about it. Of the 308 parliamentarians that I sent my materials to in August, I heard from two people. Two members of Parliament responded. Don Davies, who responded with a letter to Jason Kenney that Jason Kenney ignored, and Elizabeth May, who phoned me and spoke to me on the phone and then didn't do anything. So of the members of Vancouver City Council, I contacted the mayor and all members of council when Mr. Cheney was coming. The members of that governing body that responded was exactly 0 people. The members of the Surrey Council, I forget how many councillors they have, maybe it's 9 or something, plus the mayor. The only reply that I got was from the mayor's, one of the people in the mayor's office who set up a telephone meeting between me and the mayor, and then subsequent after that canceled the meeting. I received no response whatsoever from any of the elected members, nor did I from the Attorney General of British Columbia. Now, Ms. Watts and other elected officials, not only are they ignorant of the law, or whether it's skillfully or willfully ignorant or just plain ignorant, I don't know the answer to that, but they also apparently are ignorant of or just don't understand that equality before the law, equal protection of the law, and equal access to remedies for violation is the most basic legitimizing principle of our legal system. And that the people who are the victims of the crimes committed by the Bush administration and are crimes committed in Canada once he crosses the border, then all of those victims are entitled also to the remedy that is available through proper prosecutions in the criminal justice system. And obviously, if those victims don't get those remedies, then those crimes will just continue. And I just want to say a few words about the devastation that non-enforcement would lead to. Let's say we had another Iraq, The scientists estimate in Iraq that the number of people that have been killed as a result of the illegal war is over 1 million, and those figures come from, first of all, the Johns Hopkins Bloomsbury study. Their scientific study estimated as of July 2006 that there were over 655,000 people that had died as a consequence of the war as of July 2006. The British polling agency Orb estimates deaths resulting from the invasion and occupation as of September 2007 at 1.2 million. Just Foreign Policy estimates excess deaths in Iraq as a result of the invasion and occupation as of October 2010 at 1.4 million. And I just mention those figures because, of course, when the Iraq War started, Tommy Franks came on CBC, just couldn't stop running him. They just seemed to love this clip of him. It ran for about 22 minutes. And at the end of it, he said proudly, "We don't do body counts," which that was a very good idea for them not to do body counts, because even now you hear responsible people saying there must have been thousands of people killed in Iraq. And actually, if there were only thousands of people killed, then I suggest that the American government, the British government, and other governments that were paying for all those very expensive warheads would have been asking to have their money back, because all of the armaments that were used in Iraq were intended to kill people, and they did. But those horrifying figures don't include the number of people disabled by injury or born disabled due to depleted uranium, white phosphorus, or other toxins introduced by the Western war makers. An October 2009 report by the Iraq Minister of Women's Affairs to the UN General Assembly revealed that 24% of the babies born in Fallujah in September 2009 died within the first week of life, and 75% of the babies were deformed. That compares to August 2002, 6 months before the US-led invasion started, when 530 live births were reported, with only 6 dying in the first week and only 1 deformity. Now, during the second assault on Fallujah alone, an estimated 10,000 tons of depleted uranium were used. The UN reports as to displacement, again back in 2009, the UN reports estimated 2.7 million internally displaced and 2.2 million refugees had left the country. And so during the 7-year illegal war, approximately 25% of the Iraq population has been either killed or displaced. Other damages that maybe are irremediable to the Iraqi culture and country is the Brussels Tribunal has compiled reports chronicling the collapse of the Iraqi education system. Remember that the US was bringing democracy and freedom to those poor Iraqis there. Those reports are all pretty appalling. The International Medical Corps, for instance, reports that the population of teachers in Baghdad has fallen by 80%. A UN report conducted as early as August 2005 said 84% of Iraqis' higher education institutions had been burnt, looted, or destroyed, and money for education had been and was being diverted to so-called security. The public school system had collapsed entirely. Before the Gulf War, Iraq had the highest literacy rate in the region, and it now has the lowest. Now, when the federal government published this Return These Guys In website that I was telling you about, I don't know if you heard about that, but in any case, when that happened, Amnesty International published an open letter to Mr. Kenney saying, Mr. Kenney, you've actually got the law wrong. That when the suspected war criminals are in Canada, your legal obligation is to prosecute them here or to send them to a country that's willing and able to do so. You can't simply deport them. That's not in accordance with your legal obligations. Mr. Kenny wrote a very, I guess he thought it was clever, a very scathing condemnation of amnesty on his blog site. And one of the more polite things that he said is he said amnesty was wasting its resources on innoxious, I guess he means not noxious, situations and playing politics. He suggested then that amnesty consider restricting itself to being concerned with brutal regimes. And one of the reasons why I ran over some of those, and I'm just touching the tip of the iceberg to run over those figures about Iraq, is I don't know of a more brutal regime than the Bush regime. So when people, I beg your pardon? Oh, yes, certainly there's a bit of competition there. Now, just quickly, because I'm completely out of time, and I just want to say one more word. And the thing I want to say is, well, why doesn't Canada enforce those laws? The first answer to that, in my view, that I'd like us to talk about during this next period is because they don't have to, because they can get away with not doing so. If they thought they had any obligation to enforce them, they would have told Mr. Bush not to come. But they are so secure in the knowledge that they just don't have to. They can just give privileges to their friend, whatever privileges they want, and they'll get away with it. And the sad thing is they're right. They have got away with it, and they are getting away with it, and we have to change that. The other reason, in my view, why Canada is particularly aggressive about not recognizing any of their international law responsibilities with regard to torture is because Canadian officials have been complicit in the torture in several situations, and I'll just quickly run through that. Both the Supreme Court of Canada, the Federal Court, and the Federal Court of Appeal have confirmed that Canadian officials were complicit in the torture of Canadian citizen Omar Khadr. And guess what? They not only got away with it, they're still getting away with it. Omar Khadr, by the way, after having pled guilty to a bunch of bogus charges that would have had him committing conspiracy crimes in Africa when he was 8 years old. One of the things he had to sign this stipulation of facts, it was called, fancifully called. One of the stipulation of facts that he had to agree to for this plea bargain is he had to agree that the Geneva Conventions didn't apply to him. It's very pathetic. But anyway, Omar Khadr, by the way, is still in Camp 5. How many months? Almost a year since he accepted that plea bargain, Camp 5 being the most brutal camp at Guantanamo Bay. He's still in a windowless cell. He is still chained to a metal U-bar in the floor. So there you go. But anyway, so there's Omar Khadr, there's Meher Arar, there's the cases of al-Maliki. I'm going to read their names so that I get it right, because it's rude to get it wrong, get their names wrong. The cases of Abdullah al-Maliki, Aman Abu al-Mati, and Muriad Nureddin. Those were the three men that became the subject of the Yakabuchi inquiry, and the only reason they became the subject of the Yakabuchi inquiry is the torture of Abdullah al-Maliki came up in the O'Connor inquiry into the Meher Arar case, and Justice O'Connor said there had to be an inquiry. There was. Yakabuchi's findings were criticized by the human rights groups that were knowledgeable about the cases and the inquiry into them as being a little bit of a cover-up, but notwithstanding that, Yakabuchi found that all 3 men had been tortured, and that the torture of all 3 men resulted indirectly from the actions of Canadian officials, and those actions include falsely labeling them as imminent threats, and the CSIS and the RCMP sending Syrian officials questions to use in questioning the men, the RCMP attempting to interview, and by the RCMP sharing false information with the United States. The Canadian government has maintained throughout, they haven't paid any compensation to these men, and they say, oh, we just sent questions to the Syrians as part of a legitimate police investigation. Canadian author Carrie Pither contends in her her book, which is called Dark Days, that the 3 men were imprisoned in Syria because of an orchestrated campaign by Canadian security agencies to neutralize people that they had fancifully designated as terrorists. It's kind of same fanciful thing that arose in Guantanamo Bay, because in September of 2001, George Bush passed a presidential order saying that people that are designated as a threat to the United States, non-Americans, will be held outside the United States, and they won't be entitled to the protection of the Geneva Conventions, the laws of their own state, or American law. So, and there was no review process, so he might as well have said anybody that I call a cabbage, we could cut that up and eat it or fry it however we want, you know what I mean? So basically that's just the same thing that happened with these people. The other issue that's still festering for the Canadian government, of course, is the turnover of captives taken in Afghanistan by the Canadian Armed Forces to the possibility of torture. That issue's been festering ever since January 2002. The Globe and Mail ran a picture of Canada turning over captives taken. I don't call them prisoners or detainees because that sounds legal. They're just captives. They're people that were illegally taken by force into captivity. And that time Canada was turning the captives they took in Afghanistan over to the US, and that was the first time that the issue was raised by Lawyers Against the War, actually, that they were probably being turned over to probable and likely torture. More recently, the issue was raised in 2005 by university professor Amir Adaran at the University of Ottawa, and since then Amnesty International and the BC Civil Liberties have taken a case to the federal court, which I won't tell you all the dissembling and lying and mendacity exhibited by the federal government. That case was finally terminated in federal court, and there's still ongoing the inquiry before the Military Complaints Commission, and as a result of the dissembling and the refusal to divulge to Parliament documents relevant to that whole issue, Stephen Harper was found to be in contempt of court, and that's the first time that that's ever happened. So I think that officials in both the Chrétien government and the Stephen Harper government have a lot of personal reasons for not wanting the law prohibitions on torture to be vigorously enacted in Canada. And I just see we have just joining us is Bridget DePape, who's going to be talking to you about the next topic, which is what can we all do about it. So thank you very much.